We'd also humbly request that council speaks up so that we hear what he says.
Because we can't address the topic without the police.
Yeah, I think that's what I wanted to do.
Maybe for good order, we can start with the honor, my name is Mole, and I appear together with Mr. Kim. Mr. Kim, Mr. Owi, and Mr. Tilangi for the proceedings. Tilangi. Sorry.
Humble request again. May council speak up so that we are able to record what he's saying? It will be useful to us. Kindly continue. No, I'm not. I would like to respond to what you say. So
what I'm saying is emergency. That's what it is. Okay. Brian Mwenda, Rachel Nyambura, Isaiah Mungiki. Brian Mwenda. Yes. Rachel Nyambura, Isaiah Mungiki. Mutoni Mburu, Isaiah Mungiki. Mutoni Mburu, Tiena Munare. Mutoni Mburu, Tiena Munare, Collins Ugutu, Tiena Munare, Collins Ugutu, Patrick Lamins, Keva Uchicho. Patrick Lamins. Yeah. Keva Uchicho. Among others. I will not allow all the people one person. I will address the issue of the constitution. I will address the issue of the address the legal issues. I will address the financial questions. So we are organized. Nobody will be because we are combatant.
But it's coming up. They take the advantage.
I need to bring one's attention to the following information. First, this is the first time we are meeting with our clients. They have been hidden in some car behind them, and the police have refused to allow us access. And I as I'm speaking to him, there is an officer here, this one on the side, who is coming, is dropped what we are saying, and it is unconstitutional to do so. I think it is important that the police run to allow. He's dropping. He's listening to our conversation. I've asked him to move aside and he has refused. This one, I don't know his name. It is completely untoward and disrespectful of the court process that an officer can abuse a citizen's right to have legal counsel quietly. My next point would be, we do not have a director of public prosecutions. So I do not know who has authorized the prosecution of the, or even the registration of the charges that Mr. Victor Muller is intending or proposing that they read to you.
So you're saying
We don't have a DPP, there is no authority to charge. We must remember that this is not the normal criminal prosecution. This is a political prosecution. I don't want to go to the details of the judgeship because my colleague will. But it is important to note what I've just been told right now by my client, that they were arrested on 19th. And they are being produced in court on 24th. In total violation of the constitutional rights. They have been held in Chicago. They have not been able to talk to anybody because their phones were confiscated. And this is what, but very similar to what we said in the earlier case. The police have this abnormal habit of confiscating people's phones so that they incapacitate them from even communicating with their lawyers, with their doctors, with their family, with their wives, with their husbands. What is Kenya going? This court must protect the rights of citizens. A country's decency is measured by how it treats the weakest, especially when they are arrested. If you look at the charges on the charge sheet, the copy we were given, they have how many charges? They have 5 counts. Purportedly committed on 2 different dates. Under the instructions I have right now from Mr. Maina Njenga is that he was arrested on the 19th, taken to a place he doesn't know, and blindfolded. He's now telling me there were recorded statements when they were blindfolded. The court cannot countenance this. Must reject these charges. Anyway, if you look at the entire charge sheet, in respect to the number of counts and the number of dates of their alleged offenses, there is only one person stated as a witness, Mr. Kemboy Rob, who is a police officer. Meaning, this stated that others to be stated, they are going to be manufactured. What it means really from the face of the charge sheet is that the investigation is incomplete. Because how else is they bring one state one witness who is a police officer and say they are going to state others later in life? When and why? If they had investigated the case properly, they would say we have so and so, Aaron Dubi, Mr. Mungiki, and others.
Wherever this will take us.
Victor Mule as a witness.
We have a offer, and I think this is premature. We could have taken and for good order, we make the application, we make our application. You give a consultative hearing. I thought that would be more professional and for good order.
I don't know what Mr. Mule thinks is good order if they are conducting themselves unconstitutionally. The order, good order is in the Constitution. It's not found inside the charge sheet. All I'm saying is that this charge sheet should be rejected. You will see duplicity. The accused persons have been held incommunicado and are constitutionally beyond 24 hours. Having been arrested on a Wednesday, they would have been produced in court on Thursday or Friday latest. And lastly, Your Honor, let me say this. My heart is bleeding with this country. No, whether you put it or not, I think I need you to understand, Your Honor, with utmost respect, that we are descending into a police state. See, these fellows were brought here very early in the morning. We were lied to that they would be taken to Kahawa. I was in Kahawa. They were brought here, they have been kept in, not in the cells, but in the car, outside, some car. And I personally went there to try to see them. I was denied access. What kind of country are we doing if the court can't take control of itself and its precincts? It's just like Parliament has the privileges that nobody can be arrested within the grounds of Parliament. I think nobody should be given injustice in the grounds of a court premises. These fellows have been denied their justice within court premises, and it is completely unjust. But why then lie to counsel? Why deny them access to counsel?
That is the police. The people who arrested them. They are the
It
ones.
is important.
They are the one who, if they lie to you that they take it to power, I think they are the one who lied to you. It's supposed to be.
No, Your Honor, I very humbly and respectfully disagree with you. It is important for you to query the police and the prosecution, whether they actually say it so that you can decide whether to admit this charge or not.
Also to hear from the prosecution.
Your Honor, with your kind permission, my colleague Mr. Awit will address you, but will also address you. But we'll start with Mr. Awit.
Your Honor, Ms. Kamburugu reminds me that it's also part of the prosecution team. However, Your Honor, with a lot of humility and respect for the learned senior Mr. Ndubi, we will pray that these proceedings be a little more organized, number one. And number two is that Mr. Ndubi should be a little more clearer on the nature of the applications he's making. If I got him right, one of the applications learned senior is making is that you reject the charges brought before you. And my understanding is that he's premising that application for rejection on, among other grounds, number one, a question of duplicity of the charges. Mr. Ndubi appears, I'm not sure he'll clarify, to be asking you to reject the charges on the grounds, number one, that they are bad for duplicity, and number two, that there has been a violation of certain fundamental rights and freedoms fundamental rights and freedoms under the Constitution of Kenya 2010. And finally, number 3, that as we speak, there is no substantive holder of the office of the Director of Public Prosecutions. If I got him right, I would like to respond to those 3 issues. And as I do so, because these are very serious constitutional issues raised by the Learned Council, is that this court can only operate within the confines of its jurisdiction. Your jurisdiction is defined by Section 8 of the Magistrates' Courts Act. And because of the jurisdictional issue, I'll start from that. That section limits your ability to hear, entertain, and or determine 8 of the Magistrates' Court Act 2015. That for good order, you can only hear or entertain and determine issues relating to alleged violation of fundamental rights and freedoms limited to Article 25A and B. Article 25A and B of the Constitution. And so that with a lot of empathy and sympathy, anything outside that falls out of your jurisdiction, and a proper application on the basis thereof is vested in the High Court by dint of Article 1653 of the Constitution. Having said so, the officers of the Director of Public Prosecutions, or said differently, the mandate of the Office of the Director of Public Prosecutions is exercised directly by the Director of Public Prosecutions under Article 157(1), or in terms of delegated authority by officers appointed, including the Deputy Director of Public Prosecutions. We have 2 of them before you this morning. And the signer, if that were an English word, of the charges before you, the approver of the charges, Mr. Murugu, who sits before you this morning. To that extent, the charges were properly reviewed and approved. And the validity of the charges as far as the existence of a substantive holder of the office does not arise. For clarity, the departure of Mr. Nordin Haji from the office of the DPP did not invalidate the authority of the officers of the ODPP. As correctly noted by Mr. Ndubi, the authority of the officers of the DPP is granted by the Constitution and the law being the Office of the Director of Public Prosecutions Act 2012. And does not arise from Mr. Nordin Haji or the holder of the office. On the issue of the alleged violation of constitutional rights, including holding any of the accused or any of the suspects, before they have taken charges, incommunicado, while we sympathize again, those are issues that this court cannot listen to because you lack jurisdiction, and with that you have to down your tools. And finally, the most important question is whether or not you can reject these charges because of the invalidity of the charges, to which duplicity. Mr. Ndubi has not described to you how the charges before you are bad for duplicity. Nothing at all, apart from the statement that the charges are bad for duplicity, has been told to you. In response, the charges before you are founded are on known provisions of the Penal Code, constitutional to say the least. None of them has been declared unconstitutional. And to that extent, you have proper charges based on the law, a law known in Kenya as required under Article 52 of the Constitution. Further, under Article 89.5 of, Section 89.5 of the Criminal Procedure Code, 89.5, which is the only provision this court would invoke to reject charges. The only reason you could reject charges is that the charges do not disclose an offense known in law. Count 1 is founded on Section 89.1 of the Penal Code. Count 2 on Section 308.1 of the Penal Code. Count 3 on Section 511 as read with 510 of the Public Order Act. Count 4, which may be the newest of the charges, is under Section 4A of the Narcotic Drugs and Psychotropic Substances Act as amended in 2022. And finally, count 5 is brought under Section 77.1, which has been subject of constitutional litigation prior. And the court upheld that Section 773 is constitutional within Kenya. Similar to Section 5, which also has been subject of litigation and has been found to be sound. To that extent, you have proper charges before you. But finally, even if there were alleged, violations of fundamental rights and freedoms as alleged by counsel, then the only remedy would not be to reject the charges, but to seek constitutional litigation and damages before the High Court of Kenya under Article 165. Having said that, we humbly ask you that for good order, let us proceed to take the plea and then handle the issues arising after we've taken the plea. Thank you.
I want 2 points. The other one, all the 5 prosecutors appearing before you are duly gazetted to conduct prosecutions. And consequently, by virtue of that prosecution, that gazettement, they are properly before you, they properly approved charges and filed with them.
Officer is harassing the land, but now he's receiving his medicine and he wants to take it away. I don't know what his problem is. This is medicine. You are not a doctor to confirm. No, it's incorrect. He has just received his medicine and it's being taken away from him by his fellow.
Those are other things to attach to. Let us have some order. If he has been given medicine to take, let him take his medicine. Why should you refuse him to take medicine? Prosecutor, can you just tell the police? If he has been told, if his drug is taken like that, let him take his drug, please.
Yeah, it should be answered that we finish this process. We are sorry for that. They are gazetted. We urge the court to take judicial notice to such gazetted. 2, the office of Director of Public Prosecution is an independent office within the meaning of Article 248, 1 of the Constitution, which lists independent office. 248 of the Constitution, which Read. There's a list of commissions and independent offices, but you will note the office of the DPP is not listed. But that article says, except to the extent this constitution provides otherwise. So the question is, does this constitution provide otherwise? The answer is yes. Article 157. Article 157 Article 11 provides that the Director of Public Prosecutions shall not be under the control or direction of any person or authority. This means he is independent, and that brings the office of the Director of Public Prosecutions within the purview of Article 248(1). So we are an independent office. Being an independent office, under Article 253 of the same Constitution, the office enjoys perpetual succession. The office enjoys perpetual succession, and consequently, the departure of Mr. Nuruddin Ani as the Director of Public Prosecutions does not mean that the office ceases to exist or to function. Lastly, we urge the court to make a finding that all the allegations by learned counsel have been made from the bar. They are not substantiated. They are not on oath. And we cannot poach for their correction. These are just mere allegations from the bar. We urge the court to order that the proper forum for all those arguments is the High Court, not the Holy Court. We urge the court again to order that we take plea and we make the other applications.
I'm saying,
I'm already playing the point.
I didn't name my apologies, we have not repeated what Mr. Maker said, because if we are going to do that,
I'm not going to repeat anything. What I'm saying,
yes,
Your Honor, is that
you may know your name.
number one, you are not Mr. Mungiki.
You may know your name.
Mungiki. Don't know my name, Mr. Mungiki.
It's everyone's
This country is a democracy. I was saying to you, independent offices under Article 243. Look at Article 249, A and C. Those commissions and independent offices have to protect the sovereign power of the people of Kenya. Those commissions and independent offices have to promote the democratic values in the society of Kenya. Those commissions are not supposed to be subject to any other agency or authority. So what we are saying is contextualize these constitutional values and apply them to these aspects. Number one, they were arrested on 19th. They are held in Comicado, no communication with family or lawyers or anybody. Nobody knows where they were. They are now being removed to court 1 week later. Even when the High Court gave a habeas corpus orders, they never respected them. These people are a cash pay. The High Court gave them a cash pay of 100,000 euros. They did not respect that. Your Honor, you took an oath. The oath you took was to protect, promote, and preserve the Constitution. And what we are urging you now is chancellor has said that when you look at the office of the as currently constituted, there is a problem because there is an interpretative question whether the office as currently constituted can properly refer judges against this. Because I know even in anti-corruption cases, they cannot now file cases against anti-corruption cases because the office is not properly constituted. So we want to know how do they categorize that this one they can proceed and others they cannot proceed. So that is an issue for interpretation of the Constitution. Article 157 of the Constitution, which means also. That's what comes in this. Then we accelerate with Article 214 and 249. There is an issue which is conflicting. Now, the lower court has power, Your Honor. My learned colleague, Mr. Mungiki, we has misapprehended the Constitution. And with tremendous respect, the lower court has jurisdiction where an issue regarding the interpretation, application, and the enforcement of the Constitution as a recent, it refers that matter to the High Court for proper adjudication. So what we are saying is this: now that there is a serious constitutional issue that has arisen, you will check the judges under section 59.5 as my learned colleague says of the CPC, so that you refer this matter to the High Court, you admit the subject parties to bond, who are already on bond, and attachment from the High Court, then this serious constitutional question be answered by the High Court. Then we can come back to you and tell you that Your Honor, the High Court has directed that you can proceed, or that matter is settled. That's one thing that I want to put for question.
You know, even as counsel proceeds, we understand this is an interjection. I'm allowed to do so, Senior. Senior, I have to be.
He has no audience, Your Honor. If you say no,
yes.
He has no audience.
I want to hear what we want to say.
My interjection is we understood the senior counsel to be responding to our arguments. He can only do so on a point of law and cannot raise a new issue. The issue of sending a reference to the High Court did not arise. How do we get a chance to do that?
They misunderstood the application by Ndugu. Ndugu said this charge sheet.
And number two, Your Honor, Senior, I'm not done. With respect, you're my friend.
No,
number two is that you are being told about the issue of an order. You're not being told that any one of us here was served with any order. And the nature of that order. We haven't seen the order. And that has been raised again in response.
There is an order from the High Court.
So we believe that the court takes charge of its proceedings and ensures that the rules of the game are respected.
Finish what you're saying.
Your Honor, I've given you a copy of the order and I've given you a copy of the order. The High Court had been dated through habeas corpus number E/270 gave the applicants, the subjects cash bill of 100,000. I've given you a copy. Yes. So that one I wanted to raise it after. But now that in the course of arguments, it's not that you are aware. And we served it to their email address immediately. Yes. Yes. So these subjects are already admitted. So what we are saying is this, Your Honor.
I've seen from the church, these are issues we know very well. I've seen an application to oppose one of the issues to this of let us wait.
We wait, yeah, that one. I've not mentioned that. And you can see I'm very organized and systematic. I've not mentioned anything which has not been mentioned by Mude or Ubu, because I'm blind. So I know my boundaries. So what I'm saying is this, Your Honor. These constitutional aspirations are not just paper aspirations. They are meant to be enforced. It is the court which enforces them. And that is the enduring value in our constitutional system. That's why people respect us that Kenya is governed by the rule of law. But if police are allowed to just come and arrest you and they plan you with anything, even when you have never smoked in your life, they will say you were found with Musokoto. And that's a lie. And it must be said all a lie. And yet we carry Bibles to the church on Saturday and Sunday. So let me concentrate on my reply. So what I'm saying, Your Lordship, is this. If you look at the section 134 of the CPC, it is very clear. That I understood Mr. Luke saying that when you bring a church before a trial, the statement of the church and the material particulars must be so clear so that the suspect is able to appreciate what judges are being laid against him. Then he is able to understand and prepare. If it's a matter that can take him to the gallows, he appreciates that fact from day one. That is what I understood my learned colleague raised. So, and looking at the charge sheet, on the face of it, there is a problem. The material particulars and the statement of the offense is not even consistent. It does not comply with the section Article 50 clause 2B of the Constitution, which is very clear. 2B is very clear. The statement of the offense and the material particulars must be very specific so that it's understood. That is what counsel says, that this charge sheet does not meet that legal threshold. So, what are we saying? As at the moment, there is no proper law of charge disclosing an offense before you to warrant you to take the charge. You are due now under Article 1 clause 3, I think C of the Constitution, as read with Article 159 A, is you are powers of the people of Kenya. You declare that these subjects go home on reason of the cash bail, they will attend court or whatever they want. Whenever they want, they will report. But they will report as and when needed until proper charges are brought. Not these concocted charges, Your Honor. This is a democracy. So we are beseeching you, if you look at our Article 10, look at the preamble, look at the Article 20, clause 1. And I want you to read them. When you read them, it says, state officers, including judicial officers, are obligated to preserve, promote, fulfill, and protect the suspect. Yes. So, Your Honor, you are not writing, but I hope you do.
No.
Yes, I can observe. I'm a good student.
What I'm saying is, yes, to tell the right principles and values of the law, and I know them.
Because only if you are not writing, how will you remember?
I will remember.
After we finish it, we will have nothing in the record. Yes. So what I'm saying is this. We have come before. The Lord of Abraham has given this position to be here now, today, so that the history is on your side. You can either build yourself so that you are a better and excellent judicial officer, or you can also be among the statistics that you once served in the judiciary.
You're not, I don't know
That is
whether
a fact.
the court should take it.
I'm not recording that.
Yes.
Yes.
I don't want us to take a lot of it. Until we determine these issues of race, let's now try to see if we move forward. And I think, Mr. Ojeki.
In fact, what we are saying in order is already bail.
It's okay.
You cannot intervene in application that they are imposing bail.
No, we have not even gotten to that.
Yes. So I'm asking you that you will make a finding that these charges violate section 89.5 of the CPC, and you reject them, so that you will give further orders.
I've recorded all that.
Yes.
Yes, exactly. This was the reason when they were arguing, and I am seeking leave of the court to answer that one.
Perhaps you want to.
I'm also leave.
It's okay.
No.
It's okay.
Now,
Before you
I
say.
want us to have some more.
Don't allow
We are not
anybody
going
to speak.
We are not going
If I am making a judgment, you are ruling.
No, the only thing was a question. I think heard you mention that there is an application or an affidavit of posting
No,
day.
what I'm saying,
Yeah, an affidavit of posting day, which I
I've
have
looked
not
at the
seen.
judge. What I'm saying is that the judge sheet is here,
Yes.
and when I've looked at it before I came in, so I saw this application. So I'm saying, let us go in and see, let's get there first, yeah?
Unfortunately, we haven't been served.
We have served.
That's the point.
We served registered. We served.
Oh, they served.
And look, we served this on it.
No, I have said.
I apologize.
Thank you, sir.
I apologize.
So, Your Honor, may I address those
What
points?
issue do you have to address?
They have talked about cases of anti-corruption not being brought to the
No.
I will tell you
No, no, no.
why. Because it's a legal point, Your Honor.
It's okay, that one, I did not even record the issue.
Thank you, Your Honor. We are guided. We are guided, Your Honor.
So, I think let us get to that point. Okay, what I'm saying, these are very serious offenses. I've looked at the judges, and when I've read some issues, which need to be examined, and the prosecution has responded to them, I'll defer this plea to 1:45 p.m. I'll make a ruling, and just to quickly make a ruling on those issues, yeah? Then I'll come back. 1:45 p.m.
Okay. Remind me later in the evening.
Usiallow watu kuingia. Nyinyi. Usiwache watu kuingia, watajaa kwetu. Wakae nje. Watu wakae nje.
Just asking.
Mambo iko aje?
Wakili Odieki anaitwa hapa. Wakili Odieki anaitwa na chama, mwambie anaitwa na chama ni Maina Njenga. Kwani iko nini? Nilikwambia huwezi kufa kutoka asubuhi mpaka jioni.
Kuna